This training is actually one of two trainings regarding privacy and confidentiality of behavioral health information. This training looks at the issues of privacy and confidentiality from a slightly different perspective than the other training. This training consists of watching this video, reviewing the short handout regarding 42 CFR Part 2 that is included in the lesson media section of this lesson, and then completing the quiz that is included in this lesson with a passing score of at least 70%. I hope that this lesson improves your understanding of the federal confidentiality regulations. All behavioral health organizations will have some type of policy statement regarding the privacy and confidentiality requirements of all positions within the organization. In this slide, we see an example policy statement. All staff members will comply with federal and state laws and regulations pertaining to the confidentiality of clinical records and information. Staff members are required to receive confidentiality training upon hire and annually thereafter. All personally identifiable information will be kept confidential and will not be disclosed unless expressly permitted by 42 CFR Part 2, the Health Insurance Portability and Accountability Act, and Florida statutes. The laws that exercise the greatest burden regarding confidentiality are the two federal laws, 42 CFR Part 2 and HIPAA. It is also important to note that where applicable, the more restrictive of the laws applies. In this example, 42 CFR Part 2 is more restrictive than HIPAA, so for individuals receiving substance abuse treatment services, the restrictions in 42 CFR Part 2 apply. In addition to the policy statement in most organizations that typically defines the confidentiality of the information regarding persons served, the policies also typically include an orientation training at the time of hire for all staff members and then annual refresher trainings thereafter. The annual refresher trainings are important as issues regarding privacy and confidentiality of clinical records continues to be impacted by changes within our society. Recently, the confidentiality issues regarding health information exchanges and telehealth were clarified, and these changes should be part of any confidentiality training. There are a number of situations where it is permissible to release clinical records, including identifying information. The first and most common situation is that the person being served has completed an authorization to release the information. Please remember that the information in the record ultimately belongs to the person being served, and so it is their right to identify when they want to release the information. Properly executed releases should specify exactly what information is to be released and specifically to whom the information is to be released. The second situation, and another situation that occurs frequently, is that information may be shared with other staff members within the organization on a strictly need-to-know basis. So case consultation with a supervisor or a team may occur without a release of information. But even in these situations, the less identifying information that is shared, the better. Do we really need to know the person's name in order to participate in case consultation? At the other end of the need-to-know spectrum is when the staff member seeking access to the record has no legitimate need to know. So I notice that my neighbor is sitting in the waiting room. I have no legitimate need to look at his record. My curiosity is not need to know. Access to a record in such a situation would be a violation of both HIPAA and 42 CFR. if the person is receiving substance abuse treatment. The next situation where records may be released is after the receipt of a properly executed court order that has been signed by a judge. A subpoena does not compel the release of behavioral health records, but a subpoena may compel the presence of the person in the courtroom. The 42 CFR Part 2 regulations describe a specific court procedure that must be completed prior to the issuance of a court order for the release of substance abuse treatment records. Next, information can be released regarding a person served without an authorization if the person is experiencing a medical emergency or has committed or threatened to commit a crime on agency premises or against an agency employee. While the release of information is permissible, the standard of minimally necessary information still applies. Exactly how much treatment information is needed to be released in the event of a medical emergency or to report a criminal complaint. Finally, clinical record information can be released to an agency with whom the organization has a contract for the purposes of program audit or review. When an auditor or reviewer does show up to complete such a review, it is a good policy to request that the individual completes a confidentiality statement to indicate that they understand that the material that they are reviewing is confidential and may not be re-released. One of the very common occurrences where we need to make sure that we are abiding by the regulations regarding confidentiality is receiving a telephone call from someone other than the person served who is asking about the services or treatment of the person served. There are two important issues related to confidentiality regarding telephone contact. First, when a person calls us, there is no way for us to verify the identity of the person calling. That person may identify themselves as someone for whom we have a release of information, but if we cannot identify the person calling, we really have no idea who that person is. The second issue is that we need to verify that we have a signed release of information that specifies the information that the person is requesting. Therefore, the recommended action when receiving a telephone call asking for information about a person served is to take the name and telephone number of the caller. Then we can take one of two actions. We can notify the person served that the person has called and provide the person served with the name and telephone number of the caller. The other action that can be taken is that we can verify the release of information and what information may be shared, and then call the person back using the telephone number that is on the release of information. This action gives us more assurance that the person we are talking to is actually the person named on the release. One last thing about telephone calls. We should be very careful in sharing any information about a person served over the telephone. The rules of confidentiality do not prohibit the caller from providing us with information, as long as we do not in any way verify that the person they are describing is a recipient of services. In short, the caller can tell us anything. We can't tell the caller anything. The federal confidentiality laws for substance abuse services are located in the second part of Section 42 of the Consolidated Federal Register, hence how we refer to it, 42 CFR Part 2. The restrictions regarding the release of information are much more strict regarding substance use services than the confidentiality requirements under HIPAA. The increased protection of substance abuse treatment records was instituted to encourage individuals with substance use disorders to enter treatment. The reason that substance abuse treatment records are granted additional protections is that many individuals with substance use disorders fear that they will experience discrimination, stigma, legal penalties, and other negative consequences if knowledge regarding their substance use becomes public. Something as simple as forwarding a bill to an insurance company for substance abuse treatment may have unforeseen negative consequences. And I think that this is a good example of the difference between HIPAA and 42 CFR. Under HIPAA, disclosures for the purpose of payment do not require written authorization by the person served. But under 42 CFR, the person served must give explicit written permission for such a release of information and may specify exactly what information may be released to the payer source. Just like with HIPAA, 42 CFR Part 2 prohibits the disclosure of substance abuse treatment records without the written consent of the person served. Also, like HIPAA, the law outlines the exceptions to the requirement that written consent must be obtained prior to the release of information. Some of the exceptions are the same as in HIPAA, others are slightly different, and some exceptions described in HIPAA are not permitted in 42 CFR. The ones that are the same are listed first on this slide. They include medical emergencies, child abuse reporting, reporting of a crime committed on agency premises or against agency personnel, audit activities, research requests, and qualified service organizations. However, 42 CFR has a higher burden on what information is released in these instances, with the minimally necessary information standard applied to any release. For example, to report a crime by an individual on agency premises, it will be necessary for the agency to release identifying information regarding the person committing the crime. However, there is no necessity in this instance for the agency to release what type of treatment the person is receiving at the agency, so it would not be permissible to include this information in the criminal report. The same restrictions would apply to a child abuse report. Again, identifying information can be released, but treatment information cannot be released. One exception that is slightly different under 42 CFR is the exception regarding court orders. 42 CFR permits the release of information in response to a court order without a written consent for the release of information. However, 42 CFR requires a legal process called a show cause hearing to be completed prior to the issuance of the court order. The show cause hearing is designed to explore the legal necessity of the information versus the right to privacy of the individual served. I would like to add from personal experience that very few courts or attorneys are aware of these requirements. I was once called to court to show cause why I should not be held in contempt for responding to a subpoena with written notification of the requirements in 42 CFR and notifying the party issuing the subpoena that I would not be present until presented with a court order issued after a fully compliant show cause hearing. The worst of these offenders is the situation is for probation violation hearings, and the use of treatment information for evidence in a probation violation hearing is one of the items that is specifically prohibited in 42 CFR. Just to reassure you, I did not go to jail for contempt, but my feeling was I was pretty close to doing so. My advice to any of you is that if you receive a subpoena or a court order for testimony or records regarding substance abuse services, you turn that document over to your Health Information Management Department or to your agency attorney for a response to that document. 42 CFR also prohibits the redisclosure of substance abuse treatment information by a person or agency that has received the information on the basis of a signed consent to release the information. All information that is released must include a notice that the information is protected by 42 CFR Part 2, and that any redisclosure of the information must be in compliance with 42 CFR Part 2, basically stating that if the recipient of the information wishes to redisclose it, they must first obtain a consent to release the information from the person whose information they possess. So, there are two major pieces of federal legislation that define the confidential handling of treatment information. The more general law is the Health Insurance Portability and Accountability Act, more widely known as HIPAA. The HIPAA law applies to any type of medical treatment and defines protected health information, or PHI, which the law describes as any medical information related to the person and any information related to the person that could potentially be used to identify the person. While the HIPAA law established some broad privacy standards, there are a number of exceptions in the law that allow for information sharing without the individual's written consent. The law also has major sections related to the security of stored protected health information and computer protocols for the exchange of electronic PHI. 42 CFR Part 2 is a very specific law that applies only to substance abuse treatment. Additionally, as noted before, the exceptions to the ability to release information without the individual's consent are more limited under 42 CFR. Also, as indicated before, one of the protections granted in 42 CFR that is not granted under HIPAA is the protection of substance abuse treatment information from being used in law enforcement or legal proceedings. Let me give you a very real example. You're providing substance abuse treatment to a person who is on state probation. You have a release of information to the probation officer that grants you permission to release information related to progress in treatment. This particular person dropped out of treatment before completing treatment, so you send a report to the probation officer that states the person did not complete treatment. So far, so good. A couple of months later, you receive a subpoena to appear at a probation violation hearing regarding this person. So as not to be held in contempt, you show up for the hearing. You are called to the stand, and the assistant district attorney asks you if this person completed treatment. Understand that the court already knows that the person did not complete treatment because of your report to the probation officer. But your report to the probation officer is not admissible evidence because it is secondhand. What is your answer to the question from the assistant district attorney? The correct answer is the following. The information that you are requesting is protected under Federal Law 42 CFR Part 2. That law states that the information cannot be released to a court without the issuance of a court order after a hearing to show cause for the release of this information. You then look at the judge, and typically the judge looks at you as if you were speaking Greek. The judge then says to you, "Answer the question." What do you do? The correct answer is that you answer the question. You have been given an order of the court. It is up to the trial attorneys and perhaps an appellate judge to determine that the order of the court did not follow from a hearing to show cause for the release of the information. I know that this happens, and it is a violation of the court. It is not a violation based on the individual providing testimony. Finally, 42 CFR is more restrictive related to the release of information without the individual's consent for the purpose of treatment, payment, or healthcare operations. As previously discussed, for substance abuse treatment, a release of information form must be signed by the person receiving services in order to release information for these purposes. In 2017 and again in 2018, the regulations in 42 CFR Part 2 were amended. The Substance Abuse and Mental Health Services Administration held hearings and feedback sessions regarding the proposed amendments. The purpose of the amendments was to improve the ability of treatment providers to exchange information for the purpose of coordination of care and to improve the quality of care. The first change in the amendments allows for the release of information under 42 CFR to all of their treating providers in organizations that are involved in integrated care settings, including health information exchanges, networks of care, and accountable care organizations. A release form is still required, but the form does not need to list the names of each healthcare provider. The release form can now permit the disclosure of the information to the entire organization, as long as that organization has a treatment provider relationship with your organization. The second change allows a general designation and time frame for who the release of information is for. Previously, the law required a specific person at an organization to whom the information would be released. Now, the release can be to any and all treatment providers at the organization, and the release can even reach into the future to include future treatment providers at the organization. The importance of the protections granted by 42 CFR Part 2 are that they provide reassurance to individuals seeking substance abuse treatment that their treatment can remain confidential, so that the individual can avoid negative consequences because of their seeking treatment. With the lethality of some of the current drugs of abuse that are available, the access to confidential treatment has never been more important. On this slide is a link to a handout developed by the Legal Action Center regarding the important parts of 42 CFR Part 2. Rather than having you look this information up, this handout is included in the lesson media section of this lesson. This ends our training on privacy and confidentiality. Please review the handout material that is included in the lesson media section of this lesson. To complete this lesson, you must complete the quiz that is included with the lesson with a passing score of at least 70%. Thank you, and good luck.